May seek your lordship indulgence. My lord, I'm mentioning on behalf of Mr. Aldrin Lalomzuala with regard to item 2, part 1. If it, part 2, item 1. If it may be listed again after 2 weeks, my lord, since he's currently having personal difficulties. I've taken the consent of the appellant as well. Yes, part 2, item 1. Yes, from appellant. Number 3. Two weeks, my lord. Obliged, my lord.
Motion, item 1.
With most respect to your lordship, if I'm allowed to represent my case, my lord, in person.
Oh, sorry.
Yes, my lord. I hope I'm audible, but I cannot hear your voice. But if I'm allowed to continue, my lord.
Yes, please proceed.
My lord, I am here before your lordship challenging the order passed by Magistrate Saidapet that the impugned order will be found in page 93, my lord.
Mm, 93.
My lord.
Yes, please read.
Yes, on dated 3rd March 2025, Metropolitan Magistrate has passed an order with a direction that as per the order passed by this court dated so-and-so in criminal miscellaneous petition number so-and-so, the investigating officer is hereby directed to issue necessary direction to the concerned bank to defreeze the below mentioned bank account number so-and-so and to transfer the said amount, or if it is less than the same, the remaining available balance amount to the account of de facto Axis Bank account number so-and-so, and submit the report to this court forthwith. Now, under that, there was 2 bank accounts, 1 and 2. Number 1, HDFC bank account is my bank account, my lord, wherein this learned magistrate has directed rupees 27,90,009 rupees to take from my bank account. On what basis, my lord? Without any basis, my lord. Just because the complainant, case IO, is filing a application and the person who is in the de facto complainant is the one who is filing FIR. So, in favor of the one who is filing FIR, the case IO is filing an application to the magistrate to take my money from my account, my lord. So, my lord, this order have been passed in my prejudice without any giving notice to me or adding as a party or hearing me, my lord. So this order is in complete violations of natural law of justice, my lord, principle of natural law of justice, my lord.
Okay, so there's a complainant. Who is the de facto complainant?
De facto complainant is respondent number 5, my lord. He appears to be one business person, my lord. So from the records, it appears that this de facto complainant, D.K. Chandrasekharan, had done some business with other person. So in the process, he has lost some amount of money. There is nothing linked with me with the de facto complainant, my lord. His account statement has been furnished in
But your name
page-
is not reflected anywhere. So this.
Correct. Correct, my lord. My
So
name
serial number 1 is HDFC Bank. So
Yes.
how can you link this account to your name? Do you have anything?
This is my account number, my lord.
So where is
So,
the account book? Where? What? How can we just say that this
yes,
is?
my lord.
Do
My
you
lord.
have some document here?
Based on that order, my lord, the case IO has emailed the branch manager, respondent number 1.
No, but how is this bank account linked to your name? Is there some document here showing that this belongs to you or
my
this
lord,
is your
this
bank?
is-
Have you enclosed some document?
27, my lord.
Page 27.
My lord.
Yes.
So, account number was there. That is my account number
Okay.
at the right side.
Wait. Okay. Yes,
the right
so
side.
this is the account number. Account branch is Kolasib. So when the account branch is at Kolasib, this order which you showed me, page 93. Account number, but the branch, nothing is shown, is it? So maybe there was some mistake. How come your this thing? Account branch is Kolasib and ground floor.
IFC code is
Deal
there in the
facility.
order, my lord.
Ah.
That is the Kolasib branch IFC code,
Okay.
impugn order.
You see, I'm just a bit curious. This is an order made from Chennai.
My lord.
And they come and transfer the account, deposit it in the Kolasib branch, is it?
My lord, my account is in Kolasib branch, and these people are trying to extort my money based on this order.
So have you spoken to the Kolasib branch where you have deposited your money?
Yes, my lord, my money was there, so it was freeze. My account was freeze. So when I inquired to the branch manager,
Yes.
I was informed that there was a complaint. So we had received an email. Based on that, we had freezed your account. So I was not happy on the actions of the branch manager. I had also filed a criminal complaint in the magistrate first class. And thereafter, they had filed a written objection, the bank authority, disclosing this judgment passed by the magistrate first class, Saidapet. So they are saying that due to this order so and so, we had freeze your account and now it is defreeze. So I am not able to use my account due to this order passed by the Saidapet magistrate. And this private respondent number 5, who is the person of initiating all this case, had also filed a written objection. So in his written objection, he had disclosed all his accounts. Why he is claiming this? And he has also disclosed the FIR. So we can find it from this record that nothing in his account transaction or nothing in his FIR I was
Where's
connected
the FIR?
with.
Is the copy of the FIR available?
My lord, yes, available, my lord.
Page? Page?
I'm coming, my lord. It starts from page 42. And the content starts from page 43. FIR. May I read?
Yes, please do.
FIR contents. Honorable Sir, I, R.V. Gotham, working as a DSP State Cybercrime Wing, Ashok Nagar, Chennai, so and so, on 14 February 2025, at 5 p.m., while I was in duty, Mr. D.K. Chandrasekharan appeared before me, gave the following written complaint from D.K. Chandrasekharan, address so and so, to the Deputy Superintendent of Police, Cyber Wing, Ashok Nagar, Chennai 83. Respected Sir, subject cheating in the name of stock and shares by exchange known as Aditya Birla Online Trading and defrauded a sum of 5 crores from my Axis Bank current account. I am a permanent resident in the above address and a businessman in Karur and Tripur for the past 25 years. I am having 2 children and one working in Bangalore and one studying in Chennai, and my wife is doing homely work. On 5/12/2024, Mrs. Aliana sent me an invite to join in a WhatsApp group named VIP 26 Aditya Birla Wealth Enhancement. I got to know about this online trading shares through Mr. Ayana Joseph, and she asked me to download the apps Adit Pro. Further, on 2012/2024, have transferred amount of rupees 50,000 to the receiver name Sanam Enterprise through net banking. Again, on 31/12/2024, they joined me in a new WhatsApp group named Issue 19 Aditya Birla Core Membership Group and admin number so and so, which I'm a participant, where he give advice and recommendations of the online trading shares through WhatsApp. And other member of this group, Mrs. Pooja Rathore, number so and so, Noida, who's trading this in platform, called me and said she also trading in this group and getting profits. So I have downloaded the app and submit my all fund and bank details in that platform. Customer care called me and asked me to make deposit fund through all their recommended bank accounts. I have transferred amount 18 times for the allotment of new shares, and same was reflected in my exchange account. In exchange, it shows there were 2 instances where they told me that I had a profit from my purchase shares with profit of 22%. And daily night, there will be conversation between all members in group name as Aditya Birla Core Membership Group. Every day, we will give details about the company shares and IPO shares to be purchased on the next day. So I have transferred the money to the different bank accounts given by the customer care fraudulently and frequently and trade in platform. For this case, I have borrowed money from friends and private finance to subscribe for IPO shares, OTC shares purchase, and last they asked me to pay service charge of 15%, amounting 5 crores for all my whole transactions. After the negotiation with Mr. Aliana Joseph and customer, I pay 5%, amounting to rupees 16 lakhs, so and so, last payment on 31st January 2025, through my Axis Bank account, and I applied for withdrawal of amount in my wallet. What I have paid through the bank and all my transaction profit in my wallet, and they have informed me that I have to pay tax of 15%, amounting to 5 crores, so and so. I have discussed with our auditor, and he said it looks like a scam. So kindly check with Aditya Birla Money Limited, Chennai. I have visited and overlooked the fact that this exchange is a whole scam and fake app. I was informed till today to pay tax amount in order to withdraw the amount from my exchange account. At this stage, I realized it is a fraudulent trade, and I was being scammed by transferring the funds to multiple accounts in order to do the transaction in the trade exchange. I have given complaint to 1930 portal on 6 February 2025, and the acknowledgement number is so and so.
Okay, so details of the transfer money is here, isn't it?
Correct.
Now,
Correct,
in
my
the
lord.
list of details of transferred money, is your bank account number mentioned somewhere here? No.
No, my lord. No.
There are 18 numbers of bank accounts. Is it transfer money details?
Yes,
So is,
yes.
does your name is not in this 18 numbers, is it?
Not my name, not my bank account, my lord.
Okay.
Moreover, he has endorsed the details transactions also.
Okay, then please continue after the serial number 18.
Oh, all right.
Then below are my account details. Okay, this is,
Below are
read
my
from there,
account details.
yes.
Yes, account number so and so. IFC code so and so. Nandi Design Bank Axis. Karur branch. I therefore request you to take appropriate legal action against this person involved in this scam and recover the 5 crores money which is deposited by me in different accounts for doing the transaction in the exchange. Thanking you. Yours faithfully, Chandrasekharan. Honorable
Okay.
Sir, as per the instructions of the senior officers today, 14 February 2025, I received the complaint and registered a case in so and so under section so and so at 17:30 hours. The original FIR along with the complainant were sent to the Honorable 11 Magistrate Court, Saidabad, Chennai, and concerned officers and took up the case for investigation. Deputy Superintendent of Police, State Cybercrime Wing.
Okay, so based on this FIR, the Metropolitan Magistrate passed this order, is it? Page
Yes,
93.
my lord. Yes, my lord.
Well, your name is not reflected in the list of persons to whom money was transferred. Okay, so what is your prayer? Your prayer is for
My
a
prayer
stay
is,
of
my
this
lord,
order? When was this
Yes.
order passed? March. So that your money is not transferred to the account of this person, de facto
Yes.
Axis Bank.
Yes, my lord. Now, based on that magistrate order,
Okay, till
is
the,
claiming.
yes. Now, who have you made the parties in this petition? Who were the parties? The respondents? The bank?
yes,
Let's see.
bank are number 1 and 2. Number 3 is the state of Tamil Nadu. Number 4 is the case IO. Number 5 is the private respondent who is filing the FIR.
So now the private respondent also, if he does not mention that he has transferred any amount to this bank account, I think the matter can be clarified. How is it that your bank account number has been mentioned in this order, isn't it?
Very strange, my lord. How I
Anyways,
was picked up.
we'll see. We'll issue notice that,
Then, my lord, in the interim, let the order of the magistrate be stayed, my lord. Otherwise, they are claiming continuously, my lord.
yes, okay. Heard Mr.
That's my lord.
That's what. I'm looking at the names in the cost list. You are the Lalsoirema, but the council is Lalthang Moya.
Yes, my lord.
But Lalthang Moya has not appeared. So you're representing your case, isn't it? Here the case is Lalsoirema and your council, as per the cost list, is Lalthang Moya. That's why
yeah.
I'm just, where's Mr. Lalthang Moya? He's not here? You're appearing for your case, that's a different matter, but the counsel for the petitioner, your counsel is Mr. Lalthang Moya.
Yes, he's from the outstation and he's unable to reach in time, my lord. He's coming from his village.
See, you're the party,
My lord.
so you could represent your case, so the name, the counsel for the petitioner as reflected in the cost list should be your name also, not Lalthang Moya. Isn't it? And that's why I'm pausing, because when I say heard, it is Mr. Lalthang Moya. So you're saying you're taking up your own case, is it?
My lord.
That can be done, but you don't need a counsel that, yeah. heard Mr. Dal Soirema, the petitioner, who is appearing himself in the case. The petitioner submits that the instant writ petition filed under Article 226 of the Constitution of India is assailing the order dated 03/03/2025 passed by the Metropolitan Magistrate, is it?
Yes, my lord.
Passed by the, it is the 11th in Roman, okay, 11th Metropolitan Magistrate, comma, Saidapet, comma, Chennai, in criminal number 15/2025, wherein the order directed the respondent number 4 to defreeze and transfer the amount of rupees 27,90,000 and 9 from the account of the petitioner at HDFC, Colosseum branch, account number being 501-006-11946737, without any legal justification or giving notice to the instant petitioner. Full stop. The petitioner submits due para that the impugned order was based on an FIR filed by respondent number
5.
5, alleging that he was alleging that he had transferred a fund to different accounts by a company or group named Aditya Birla Co-Membership Group, which he later discovered was a scam, and that being deceived by the said scam, he had transferred a sum of rupees 5 crores 34 lakhs 5 crores 34 lakhs 35,513.
If I may, my lord.
Yes, is that amount correct? Yes.
He has never mentioned the exact amount which he deposited to that party for investment. The
Okay.
only thing he deposed was that he had to pay a tax of 5 crores. to that
wait,
party.
in a scam operation, just cancel the amount, in the scam operation, wherein he had deposited a sum of 5 crores, is it? As
Not yet.
tax.
Yes, he was asked to deposit. He did not deposit, but he was asked to deposit.
But
That
then
is
here
his
you're
total.
saying that he had transferred money, isn't it? How much did he transfer then?
He does not mention it, my lord. The
Okay.
amount he
He
transferred.
had transferred a huge amount of money to different
The only
accounts.
person-
Okay,
The
to
only
different
amount he
accounts.
mentioned-
Is it to different accounts?
Yes,
Amounting to as many as 18 numbers of account.
correct.
Full stop. The learned counsel submits, the petitioner submits that on the perusal of the FIR and the 18 numbers of accounts wherein he had transferred his money does not in any way reflect his account number at the Colosseum branch. However, the impugned order dated 03/03/2025 has defreezed his amount to be transferred to the account of the respondent number 4 without any valid reason and without issuing notice to him, and hence the instant writ petition. Full stop. The
Respondent number 5, my lord.
to the account of respondent number 5 instead of 4. Okay.
My lord.
The petitioner thus submits that, the petitioner further submits that unless the impugned order dated 03/03/2025 is stayed, he would be suffering irreparable loss. Full stop. Having heard the submissions made by the learned counsel, by the petitioner, you're the petitioner, you're representing your case, isn't it?
My lord.
By the petitioner, this court find it appropriate to issue notice to the respondents to registered post with AD within 3 working days, returnable by 3 weeks, list after 3 weeks. Meanwhile, this court, considering the nature of the submissions made by the petitioner, find it appropriate to stay the operation of the impugned order dated 03/03/2025 till the next date of listing. Yes. List after 3 weeks.
I'm obliged, my lord.
Motion item 2.
Yes.
Yes, may it please, Your Honor. Lordship, this is a writ petition filed under Article 226 of the Constitution of India, whereby the petitioner is seeking constitutional and statutory reliefs against the continuous illegal and exploitative action, utilization of the petitioner, who is a Group D employee, as Group C. So, Lordship, petitioner has been initially appointed in the year 2011, 1st July, which is given in annexure number 3 and 4.
So anyway, so what is your prayer? Your prayer
Lordship.
portion?
Our prayer is, Lordship, it's given in.
You see, simply saying my service has been utilized like this, so I should be appointed. Is there a sanctioned post for that appointment?
No,
What
Lordship,
is it then what is here this thing?
So,
Prayer?
Lordship,
I'm just
the
curious.
petitioner, which is a Group D employee,
So you want that you should then start performing the work of a Group D, is it, and not be a driver?
not exactly, Lordship. So,
Then-
what we're seeking is that, Lordship, we're not asking for any new, what do you call, service rules and anything like that.
Okay,
What we're saying is that to consider our case, which we are fully
How is it to be considered?
Sorry.
What is the relief that you're praying for? How is your case to be considered? On what lines?
Lordship, what we're seeking for is that let DPC be constituted, Lordship,
For promotion.
for promotion or either to consider our case. Since, Lordship, we have all the required,
But is there, how can you upgrade the post of a driver grade 3?
certainly, Lordship. So the thing is, Lordship, we are a Group D employee and there's a separate rules governing our employment, Lordship, which is the Group D Post-Recruitment Rules 2019, which has been amended from time to time, Lordship.
At the most, what we can do is we can tell them, okay, stop utilizing their services as a driver. Since they have being appointed as Group D, let them they perform the services or utilize their services as a Group D.
No, Lordship, the thing is, we have all the qualifications and everything, Lordship, which offer,
But is there a
Drive.
post that is available?
there is, Lordship, there is a post available.
Then you apply for that.
No, the thing is, Lordship, that we
What
are
do you do?
not,
Can
there is
you-
no
The
any,
relief that you're claiming for,
there
is
is
it
no any
possible?
promotional avenue for us as a Group D employee, Lordship. And we have applied for it and we have even filed for representation regarding this
Where's
case.
your representation page?
Representation is given on page number, annexure number 9 and 10. It's given in-
Page? I see, next year, 9, okay, it's page 31, or is it 25? No,
No, no, no,
it's
Lordship.
page
Page number 39, Lordship.
39. 39. Dated 2024. And what is the reply to your presentation?
The reply is
Have
given
they
in,
considered?
reply was given on page number 42, annexure number 10, Lordship.
Yes, page number.
So, Lordship, the reply which we received here is that, if I may go to Lordship,
Wait, page
page number 42, annexure number 10.
42. No, the only thing, page number 42, is a, yes, please read that.
Subject, representation submitted by four grade employees deployed as drivers regarding, sir, in enclosing here with joint representation submitted by 13 4-grade employees and deployed as drivers, I am directed to convey that Government of India's decision 21 under Rule 3C of CCS conduct rules has held that making of joint representations by government servants should be received as subversive of discipline, as such representation submitted by these 4 grades could not be entertained, Lordship. So after this, Lordship, they have submitted
Individually?
Yes,
Where?
Lordship.
Where? Yes.
Lordship, the representation is given in page number 45, annexure number 11.
Okay. This is dated?
Dated,
Okay, anyway, so a reply to the presentation is there, okay.
so the reply is given on page number 47, Lordship.
Yes.
If I may go to Lordship. I am to inform you that your petition for regularization, upgradation to the post of driver grade 3 has been regulated by Health and Family Welfare Department as there are no rules covering your demands for upgradation of Group D to Group C. I would like to inform you that you have submitted your petition without routing through your controlling authority. You are warned never to repeat such action in future.
So if there's no rules for upgradation from Group D to Group C, and the writ petition is for your upgradation, how can you go ahead?
So-
Are there the rules? How do you upgrade?
So, Lordship, if I have to mention this, the rules governing their employment,
Okay,
Lordship,
okay,
which
but
is
okay.
Group D Post-Recruitment Rules 2019. If I may take you to that, which is page number 30, Lordship. So page number 30. And now if I may take you to, Lordship, to section number 7, Lordship, power to transfer. If I may go to, Lordship. Notwithstanding anything contained in these rules, the Governor of Mizoram, in public interest, shall have the right and power to transfer any officers so recruited under these rules to any other post or positions which is equivalent in rank or grade. So, Lordship, they are a Group D employee, which which their service has been...
Equivalent in rank and grade.
Yes.
So you want to be transferred to Group C.
No, Lordship, what I'm saying is that, Lordship, the state has exploited their services, Lordship. These rules allows for horizontal service transfer. But now, Lordship, this is a cross-cadre transfer, Lordship, which is a Group C, which they are utilized as a Group C driver.
Is there transfer order? No.
No, Lordship, there is no transfer order, but their employment, Lordship, the appointment, Lordship, which is given in...
I don't know whether you'll have, anyways, where's the appointment order? Page?
Page number 26, Lordship. Now, Lordship, if I may go through this. Robert Vanaldikas, son of Lalming Liana Pautu, is hereby temporarily appointed as 4th grade
To be utilized as a driver.
Yes. So, Lordship, in Group D post, Lordship, there are no any mention of drivers, Lordship.
So
Which is given in-
temporary, this appointed as grade 4 to be utilized as a driver. So you're being utilized as a driver, isn't it?
Yes, Lordship.
So you're unhappy with this order, appointment order, is
Now, the
it?
thing is, Lordship, if we go to page number 32 again, if I may kindly take you to page number 32.
In your appointment order itself, it is mentioned, so because of this appointment order, you're being utilized as a driver.
Yes, Lordship.
Now you are saying that I have been utilized as a driver as per my appointment. Now what do you want? What are you praying for?
Lordship, in the Group D post, Lordship, which is in page number 32, Lordship, in the name of the posts which comes under Group D are peon, chowkidar, sweeper, and other Group D posts, Lordship. So
Okay, so are you challenging your appointment order? In the writ petition, because in the appointment order, so you should have been unhappy with this type of appointment order.
Yes.
You're silent about your appointment order, and you have been performing, so in your writ petition, you have to challenge your appointment order also,
Yes, Lordship.
because this is against, have you mentioned that? When was the appointment order? This is 2011.
2011, 1st July.
So, 1st July. So, as per your appointment order, then in your writ petition, you should challenge, also mention your appointment order. This is not as per the rules, whatever. You see, because for the department also, to appoint you as any, or to utilize your services as a peon or whatever cannot be done, because the appointment order itself mentions to be utilized as driver straight away in 2021. So you have been performing the duty of a driver because of your appointment order.
No doubt, Lordship, but the thing is,
Then what? Then you should challenge the legality of your appointment order. For the department to appoint you as anything else, it's not possible, because the appointment order itself mentions.
no, Lordship, the issue is that when there is a separate post, Lordship, which is a Group C, recruitment of driver, Lordship, when we as a Group D driver has been appointed in a cross-cadre, Lordship, which is a
So you should be challenging the appointment order. Have you challenged in your writ petition? The appointment order itself is. Mention that somewhere. So see, come again, look into that matter. You see, because even if you are going to consider a writ petition for what you have prayed for, if the appointment order itself mentions like that, and that is not challenged, then how can you have a case? So look into that, this thing in that light. If you want to amend your writ petition, it's a different matter. Now I've looked through this thing. I'm saying the appointment order itself says you should be utilized, and if that appointment order is not challenged, then this is in 2021. In the writ petition itself, you have to mention about, isn't it?
Lordship, then I'll seek your Lordship for liberty to file a fresh Lordship.
Okay. Heard Mr. Samuel L. Pachok, is it? Learned Counsel for the petitioner, who has prayed for the withdrawal of the instant writ petition with a permission to file afresh, if so advised. Praise Allah. The instant writ petition stands disposed of on withdrawal with a permission to file afresh, if so advised. With a permission to file afresh. Okay, full stop. Yes. So same in the others?
Similar also.
Similar. Just think about it, okay? Because when you look at the appointment order to be utilized as driver, that order itself appears to be defective. Yes, so same order to be utilized as driver, withdrawn, stands disposed of on withdrawal with a permission to file afresh, if so advised. Add that if so advised, okay? So same order for 2, 3, 4, and 5. Is it? Yes, similar orders. Okay.
Item 6.
May I please, Your Lordship? This is the second round of the writ petition, my lord. The earlier writ petition was disposed by Your Lordship.
Where was it disposed?
Page 272,
272.
272 to 276, my lord.
Wait, let's see my earlier order.
The
Why was it this? How was it disposed of?
the respondents are directed to consider the
Oh, their
representation.
representation. So it was considered, and
Yes, and they
your
denied, my lord.
your grievance was not addressing match, is it? So you have come before this court. Okay, let's see. Oh, why have you approached this court?
276, page
276.
276, paragraph 14, my lord.
That is the impugned order?
No, my lord, the order of this honorable court.
Okay,
And the
276.
impugned order is at page 281.
Okay. 276. Okay, so you had made a representation.
My lord.
Okay, so there is this enhanced package
My lord.
which was not given to you.
My lord.
So then
Then
your
the-
representation was, okay, considered, and this is the reply which you received, is it?
Yes.
277, is it?
no, my lord, 281.
281.
281 and 282.
So what do they say?
They are saying that the
Now read the reply of the government. This is central government, huh? Please
My lord.
read.
may I start from, my lord, the subject, my lord. Order dated 27/3/2024 of Aizawl Bench of the Honorable Guwahati High Court in WPC 19 of 2024, filed by Sri Elvis Chorke so-and-so. Representation dated 14/10/2022. Regarding payment of equal rehabilitation package financial assistance for the Bru families who had repatriated to Mizoram prior to the signing of quadripartite agreement dated 3/7/2018. Sir, I am directed to refer to order dated 27/3/2024 received in this ministry on 22nd April 2024 of Aizawl Bench of the Honorable Guwahati High Court in WPC number so-and-so, filed by Sri Elvis Chorke and 1524 others versus Union of India and 4 others. And to state that your representation dated 14/10/2022 has been considered in pursuance of the direction of the Honorable Guwahati High Court, Aizawl Bench. The following is observed in this regard. Number one, it is noted that the basic premise of your representation is that Article 14 of the Constitution of India has not been adhered to, as the families who migrated after the quadripartite agreement signed on 3rd July 2018 were given a better rehabilitation financial assistance in terms of this agreement than the families who migrated before signing of this agreement. It has also been added that the agreement dated 3rd July 2018 provided that any issue that might arise relating to the families which had repatriated earlier would be considered by the monitoring committee. And in the first meeting of the monitoring committee on 10 August 2018, it was stated that the issue of enhanced package to the already repatriated families would be considered after repatriation of the displaced families to Mizoram. It is noted that the premise of your representation is not tenable. The Brew Agreement 2018 signed on 3rd July 2018 pertains specifically to the repatriation of 5,407 Brew families identified by the government of Mizoram. The Brew families who had repatriated before the signing of the Brew Agreement 2018 were not considered under this agreement, nor does it provide for retrospective implementation. It is important to note that the package and benefit extended to the Brew families have varied over time based on prevailing circumstances. Those Brew families who accepted the package at a certain point cannot claim benefits offered at a later date. Considering subsequent circumstances, any such claim would be barred by principle of estoppel. Furthermore, the Joint Monitoring Committee constituted under the Brew Agreement 2018, which is mandated to address issues related to the early repatriated families, deliberated on this matter in its sixth meeting held on 16/10/2019. It was observed that Brews who had already received benefits under the previous package would not be eligible for benefits under the new package.
So that
That
answers
is
your case?
the impugned order. my lord.
What's wrong with the order?
My lord, if your lordship kindly see the agreement,
Okay.
Annexure 3/244. This is the quadripartite agreement. This was signed for payment of a better rehabilitation package, my lord. And in
244. Okay, so you're saying that the reply which you received from the Union of India regarding your representation
my lord.
is not as per the agreement, is
Yes,
it?
my lord.
Dated so and so. Okay, we'll issue notice, let's see.
My lord.
Instead of deciding the case now. Okay. Where's that order of this court, previous order? Page, you had mentioned the page number.
Page
Just from
272.
Okay, heard Mr. Azal Sanliana Kiante, learned counsel for the petitioner. Who has filed the instant writ petition under Article 226 of the Constitution of India, assailing the letter dated 03/07/2024 No, this is 2024. Okay, July 2024. Which is a reply to the representation made by the petitioners regarding payment of equal rehabilitation package / financial assistance for the Brew families who had repatriated to Mizoram prior to the signing of the quadripartite agreement dated 03/07/2018. Full stop. The Learned Counsel for the petitioner submits that the respondent number, they are made respondent number what? Ministry of Home Affairs?
1, 2, 3, my lord.
The respondent's number 1, 2, 3 had refused to grant
1 to 4, my lord.
1 to 4 had refused to consider, instead of grant, to consider the prayer made by the respondents, by the petitioners petitioners who are the Brew families repatriated from Tripura to Mizoram during the year 2010 to 2017. Is it? After having been displaced from the state of Mizoram to Tripura state, wherein the said petitioners in their representation had prayed for payment of equal rehabilitation package / financial assistance given to those financial assistance, okay, as per the which agreement? As per the Brew agreement, is it 2018?
Yes, my lord.
Is it? Which
Yes,
agreement?
July 2018, which is at page 244. 3rd July 2018.
As per the, okay, then between inverted commas, agreement between Government of India, comma, Government of Mizoram and Tripura and the Mizoram Brew Displaced People's Forum, within brackets, MBDPF, close bracket, dated
3/7/2018.
03/07/2018. The representation of the petitioners was rejected by the respondents number 1 to 5 on the grounds that the state agreement does not have any retrospective effect, and therefore the petitioners are not covered by the said agreement. Full stop. The learned counsel submits that this interpretation made by the respondents number 1 to 5 is not correct, and that the petitioners are also entitled to the same, entitled as per the said agreement dated so and so. Issue new para. Having heard the submissions made by the learned counsel for the petitioner, this court find it appropriate to issue notice of motion to the respondents. Full stop. Then Ms. Zairem Sampui, learned CGC, accepts notice on behalf of respondents number 1 to 5. What? Is it 1 to 4? Okay, 1 to 4. And Ms. Lunlui, learned government advocate, accepts notice on behalf of the state respondents number
5 and 6, Your Lordship.
5 and 6. Anyone else?
No one.
No need to issue formal notice. Requisite copies of the writ petition to be duly furnished to the learned counsels for the respondents. List after 3 weeks.
Obliged.
Admission, items 7 and 8.
Yes.
Lordship, in this matter, my lord, I'm seeking another 3 weeks' time to file our counter affidavit, my lord.
You're for the private respondents or what?
No, my lord, I'm appearing on behalf of my senior for the MPSC.
Respondent 2.
Respondent number 2.
Yes, my lord.
So we'll give them some more time. What about the other respondents? State?
It is respondent 3 and
Ah.
38.
So have you filed a counter?
It's more of the MPSC who has to reply now.
Okay. Then we'll give them some more time.
My lords, let it be the final, my lords. This has been happening since last year. It has been
But it's very recent, last year. We'll give them some more time. Let's see.
2 weeks, man.
Mr. Jordan Romingthanga, learned counsel for the petitioners, is present, along with Mr. Samuel Vanashya Tatsangte, learned additional AG for the state respondents number 3 and 37. Is it?
Vigilance is 38.
30.
Yeah, previously we had not, previous order is 3 and 37.
Yes, it's 37.
Pardon?
The chief secretary is 37.
So 3 and 37.
3,
isn't it?
37, 38.
For 3, 37, comma, 3, comma, 37 and 38. Then Miss
Daphne Shortlangi.
so-and-so appearing, Daphne so-and-so appearing on behalf of Mr.
Jessila Lunsanga, my lord.
J.C. Lalnunsan, learned standing counsel for respondent number
1 and 2.
1 and 2, has prayed for further time to file their counter affidavit. In view of the above, this is the matter again after 3 weeks.
Obliged.
Item 10.
And don't allow me.
My lord, I am for all the respondent. I received oral instruction in this morning. Then the matter is under process. If I may permit it, we be filing affidavit within 2 weeks, my lord.
Okay. Mr. Nelson Leanakiante, learned
My
counsel
lord,
for
last
the-
chance has been given in the earlier court date, that is 14/11/2025.
Okay, but
Final
within 2
chance.
weeks, now she's received instructions.
Yes,
isn't
my
it?
lord.
Mr. Learned counsel for the petitioner is present, along with Ms. Zairem Sampui, learned CGC, appearing for all the respondents. Full stop. So what are the instructions that you received?
My
Because this is regarding family pension.
Yes, my lord, the matter is under process, my lord.
The learned CGC submits that she has received instructions wherein she has been informed that the matter is under process and that she may be granted 2 weeks' time to file her affidavit. In view of the above submission, list the matter after 2 weeks for the learned CGC to file their affidavit positively.
Let there be a fixed date.
By the next date fixed on. Fix a date? Which one did you want her? CGC? When do you want it? Where you can file your this thing positively?
2nd February.
29, 31.
Go on, any date. You should be 2 weeks, so you'll be able to file your affidavit by which date? What? I can't hear you.
2 weeks, 2 weeks, so when? 27, my lord.
27th of January this month, is it? 27/1/2026. So you have chosen the date, the affidavit has to be
Yes,
there.
my lord.
Okay, yes.
Oblige.
Item 10,
item, this item, my lord, service of notice upon the respondent number 2 is still awaited. My lord, I have received instructions in the last week of December that no steps, proper steps have been taken, and they have inquired the PHQ. And my lord, we have found one treaty signed between Myanmar and India. So I think that will be helpful. So let me communicate that to them again, and I can inform in the next court date.
Myanmar, what is the matter about? Why-
This is an appeal by the state, my lord. It's NDPS matter.
Oh,
And there are 3 respondents, and one of them have absconded in Myanmar. He has gone back in
okay,
Myanmar.
so for issuance of notice to the remaining respondent, is it?
The respondent number 2, notice is still incomplete
Okay.
because he's in Myanmar.
Myanmar, okay. And 1 and 3, they are represented?
Yes.
Yes, madam.
Okay. Ms. Linda L. Fumble, learned public prosecutor appearing for the state, submits that she may be given further time regarding service of notice to respondent number 2, who appears to be, a Myanmar,
Yes, Myanmar national.
Yes.
appears to be a national of Myanmar. Stop. Then Mr. So-and-so, learned counsel, appears on behalf of respondent number 1 and 3. In view of the submissions made by the learned PP, list the matter again after 3 weeks.
Obliged, madam.
Orders, item 12. Lordship,
Yes.
office note dated 12/1/2026 indicates that the notice upon the respondent is not completed.
So who's supposed to take steps? Have you taken steps?
Lordship, I think my learned friend may be appear, though it is
Okay,
indicates that
you're
it's not.
appearing for the respondent. How many respondents?
Only one respondent, Lordship.
Okay. Then what is the IE about?
IA is regarding the condonation of delay, Lordship, 406
how many days?
406 days.
Are you going to this thing your
I'll have to raise
written
my
objection?
objections, madam.
You're going to raise?
Because
Okay.
and leave is required in this regard, so.
Mr. Johnny L. Tota, learned special BP for the applicant slash appellant is present, along with Mr. Lal Rokung Apavdu, learned counsel for the respondent. Full stop. The learned counsel for the respondent has prayed for time to file his written objection. In view of the above, list the matter after 3 weeks.
Madam, obliged.
Item 13.
Yes, Your Lordship, this is a state appeal, and I believe that
Yes, Rokung Apavdu, you're the legal aid counsel. Yes,
And Your Lordship, today, the application for leave is to be heard.
so we'll allow,
Madam, yes, I won't raise any objection in that regard.
I heard Ms. Vani Isyami, learned counsel for the, learned additional PP for the state appellants, along with Mr. Lal Rokung Apavdu, learned counsel, learned legal aid counsel, is it? For the respondent. This is an application filed under section 419 within brackets 3 BNSS for grant of special leave to file an appeal against the impugned acquittal order dated 27/03/2024 passed by the learned presiding officer comma, fast tracked, comma, special court, comma, POXO Act, comma, in session case number 104 of 2021 arising out of criminal trial number 1433 of 2021. Let's stop. The learned additional PP has prayed for leave to file an appeal on the grounds that there are sufficient reasons for setting aside the said impugned order, since the learned court had not appreciated the evidence adduced by the prosecution in its proper perspective. Stop. Then Mr. Lalokung Apautu, learned counsel for the respondent, has not raised any does not object, okay, to the grant of leave to file the appeal against the impugned judgment and order. Full stop. Considering the submissions made by the learned counsels, this court find it appropriate to grant the leave to the special leave to file an appeal against the judgment and order, copy paste dated so and so, so and so. Okay. Accordingly, IA number IA criminal number 53/2024 stands allowed and disposed of. Yes. Now, what is the other IA?
The other IA is the continuation of delay.
Okay.
And
Okay, then
it's already
we will
condoned.
look at the condonation. Okay. Heard Miss Vane Isyami, learned special PP, learned additional PP for the state appellants. No, let me see. This is
Delay is already condoned on
yes.
1st
Okay,
December.
delay already. So no. Okay. So now, since delay is condoned and leave is granted, now the main criminal appeal. Okay. Heard Ms. Vane Isyami, learned additional PP for the state appellants who has filed the instant appeal against the judgment and order, copy paste from previous. Okay. By submitting that, the learned trial court, again same, had not appreciated the prosecution evidence in its proper perspective and had therefore wrongly acquitted the accused of the charge under section
Then
10 of the POXO Act. Appeal is admitted. Issue notice. Full stop. Then Mr. Lalokung Apautu accepts notice on behalf of the respondent. Requisite of new line. Requisite copy of the appeal to be duly furnished to the learned counsel for the respondent. This the new para TCR to be called for. List after 3 weeks.
Obliged.
And Your Lordship, I believe that notice has also to be sent to the victim.
So Lalrokunga, okay, then notice to the victim, you're appealing, is it required? Then there will be the pro forma.
I think they have to be a party.
See, no, this is against the acquittal. This is against the acquittal. So, unless, how will they be a party? They're going to be the opposite party, then they're not required. Unless it is against the conviction, then the interest of the victim would be affected. Isn't it? What are they to say? Unless they say that, no, we don't want the appeal, we want him to be acquitted. That's the only thing. So let's see, let's call for the TCR first and then.
Yes. Obliged.
Item 14.
Yes.
Lordship, the applicant herein had been released on bail on medical grounds previously and on as an interim measure. And protection was extended several times, but was rejected by the order dated 17/11/2025. So the applicant has approached this court for granting bail as well as for, in the alternative, for
This is interim, okay. So interim bail was already over, is it?
yes, Your Lordship.
So where is he right now?
He's in the hospital, Your Lordship.
Okay, he's in
Guwahati.
the hospital, but now he is not on bail.
He's not on bail.
Ah. So once he's released from the hospital, he has to go back to jail. Is
Yes,
it?
Your Lordship.
Interim bail period is already over.
Yes, sir.
Ah. So have you approached the trial court for regularization of his interim bail or make it a regular
Yes, Your
bail?
Lordship. That was rejected by order
Okay.
dated 17/11/2025.
So why do you want, what is this thing charge under?
21C.
NDPS, what is the amount? These
Approximately 500 grams.
500 grams of heroin.
Heroin, yes, sir. So, Your Lordship, we have approached this court basically on three major grounds. First is that there were no grounds of arrest which were duly recorded and served to the applicant at the time of arrest, which is in contravention of the decision of the Supreme Court in Vihan Kumar versus State of Haryana, as well as several other citations in that regard, such as Mihir.
Let's see the thing. Grounds of arrest. No grounds of arrest. A
Yes,
copy
sir.
of the arrest memo, maybe. Let's see the arrest memo. Nothing was furnished to him. What was furnished to him on his arrest?
Nothing was furnished to him, Your Lordship. And for that, the case report has not been called for. So,
I think TPR will be required then.
yes, Your Lordship.
No, I think it will be required to see.
Apart from that, Your Lordship, if I may make
Yes,
one other submission,
the second ground?
he is presently in the hospital.
Okay,
And,
so he's been looked after. Huh?
Yes, and he has no. It is practically impossible for him to surrender himself before the court. And
Well, if it's in the hospital, well and good, let him be there.
Your Lordship,
Okay,
one thing is that on similar grounds, another co-accused, Arlal Matswani, she has been released on bail by this honorable court. She was initially released on interim bail also, but was regularized by this court by its order.
Same case, same
Same
FIR.
case, same
Same
case.
FIR.
Yes, Your Lordship. I have a copy of the order.
Let's see. But the circumstances are they the same? Huh? He must be much sicker then. Same sickness, same medical this thing. This is to this thing undergo medical treatment outside the state.
Yes, Your Lordship.
So
Similarly, the present applicant is similarly situated as he is also undergoing medical treatment outside of Mizoram
where?
in Guwahati.
Anyways, let's call for the case record first
Yes, Your Lordship.
to see whether. No, here the sickness of this person applicant with the case we had given is that presently admitted at the hospital Guwahati because she has to insert a pacemaker, heart patient. What about you? Are you also a heart patient?
Yes, Your Lordship, the concerned medical person has written
Letter regarding his.
Then here, there's another point where the case IO in his deposition also admitted that there was mistake at the time when he recorded the statement, and that okay, here it is because and warrant of arrest was issued against her pending her bail application, and that she's a heart patient having to undergo treatment at Guwahati for fixing her pacemaker. Is that the same with you? Same, how come?
Not
You also
exactly the same.
require this thing, a pacemaker.
Your Lordship, that
I
has
think
not,
it's slightly different.
yes. but he is
We'll call for the TCR to see whether there are any documents to show whether a copy of grounds of arrest have been furnished to her or not, isn't it? Because you're saying that that has not been given, no grounds of arrest. That will be a serious violation, so we'll have to see. The court has to be convinced, isn't it? We'll fix a short date. Heard Mr.
Jonathan Loving.
Yes, Jonathan Dalrin Kluanga, learned counsel for the applicant, along with Ms. Linda L. Pombal, learned PP for the state respondents. On hearing the submission made by the learned counsel for the applicant, this court find it appropriate to call for the TCR. Registry to do the needful. List immediately in the next week on list immediately after the arrival of the TCR, or make it list after the arrival of the
Your Lordship,
TCR
as per the roster, Your Lordship is not supposed to be present next week.
So, okay, similar FIR. So we will make it in this thing, then we'll make it when? This week?
Friday.
It has to be this week, but supposing TCR has not arrived, that's what, okay, anyway, call for the registry to then do the needful. List on Friday's date. Okay, that's
Obliged. Item 15.
My lord, on the last occasion, I was instructed to obtain instructions from the previous counsel what appeared for the claimant, the respondent number 1, for the MACT Aizawl. And we have made that.
what? Just come back. Unserved postal addressee left, yes.
Yes.
And so you have to find out the address.
We were instructed by this court to approach the counsel who had appeared for the respondent number 1 before the MACT Aizawl. And we have done that, and we have been informed that they will be filing their power.
Okay, but no one's
Yes.
present today.
So if this matter may be kindly taken up next week, my lord.
Okay. I heard Mr. Tila Zikima, learned counsel for the, this is what case? For the applicant / appellant, who submits that he has been informed that the opposite parties are likely to be represented by a counsel.
Oh,
Yeah.
my lord, the respondent number 1 only.
Okay, respondent number 1 is likely to be represented by a counsel. However, since none appeared for respondent number 1, list the matter in the next week.
My lord, duly obliged.
Item 16.
What's here?
Yes,
There has
IA.
been an IA filed by the Income Tax Department. Mr. Suman Chetia apparently has put in appearance for the respondents. My lords, this, even though we've received a copy,
IA, yes, but this is the first time it's
First
coming
time,
up.
yes, my lords. And the other side, I don't know who is
So
leading.
since none appeared, we'll pick some other date.
My lords, and I have only one prayer, my lords. My lords, when when notice was issued in this case on 26th August, my lords, we had
In the
sought
main WPC,
Yes,
is it?
we had sought suspension of 2 orders and the proceedings, and this honorable court was pleased to allow that interim prayer, my lords. That may be continued.
Okay. Now in the IA, okay. None appeared for the applicant on call. While just make it like that. None appeared for the applicant on call. List the matter after 2 weeks. Or make it 1 week. List the matter after 1 week. Then in the WPC. Mr. Jordan Robinson, learned counsel for the petitioner is present, while none appeared for the respondents. List the matter after. Make it 2 weeks for both, okay? 2 weeks. Meanwhile, interim order passed earlier shall continue till the next date of listing. Yes.
Great.